This is a current trends case brief presentation on the criminal case R.V. Cullinan, heard this past November 2015 with citation R.V. Cullinan 2015 NSS C35. Facts. On March 28, 2013, Rita Jordan, a 35-year-old prostitute and mother of one child, was reported missing to the Halifax Regional Police. Miss Jordan was in a relationship with Paul Trevor Cullinan, a 50-year-old plumber, and the two lived together at Mr. Cullinan's home. After much investigation, the Halifax police considered that Miss Jordan's death was indeed a homicide, and carried out a further investigation that concluded in Mr. Cullinan's arrest on June 17th. Mr. Cullinan was interviewed and questioned by many, but when the victim's mother, Donna Jordan, begged to know where her daughter was, Cullinan confessed to knowing how Mrs. Jordan had died, and as well as the location of her ashes. Consequently, he signed a Section 527 application and consented to carrying out a reenactment of the murder. The reenactment took place at Mr. Cullinan's residence and lasted about 20 minutes. Cullinan explained that Miss Jordan fell to her death from the top of a stairway at his house. The actual fall was reportedly not witnessed. This caused for the obstruction of justice, since Cullinan claimed that he had not been present at the moment of the fall, but after almost 2 years, at the outset of trial on November 2, 2015, he admitted and pled guilty to having killed her. On November 22, 2015, Paul Trevor Cullinan was found guilty and charged by the Supreme Court of Nova Scotia on one account of second-degree murder of Rita Jordan. Hence, Cullinan was convicted under Section 235 of the Criminal Code for murder, as well as for violating Section 182B of the Criminal Code by interfering with the human remains of the victim, in this case by burning her body to ashes. Section 235 of the Criminal Code prescribes life imprisonment as the mandatory minimum punishment that must be imposed for second-degree murder. Issues. Questions of fact. 1. The circumstances under which Miss Jordan fell, dying seemingly instantaneously, were expected to have a different outcome according to Dr. Wood, an expert pathologist who suggested that the nature of her death was another. Should the court consider her professional witness and opinion and admit her evidence with respect to the cause and manner of her death, nature of injuries and their significance, which implied that the fall was not an accident. 2. Dr. Wood raises a question on the type of injuries that such a fall is expected to have. What types of traumas would cause someone to die instantaneously? Decision. The defense made a motion for a directed verdict of acquittal, but this one was dismissed by the court and Cullinan was found guilty of the offense of second-degree murder with a life sentence. Rationale. Cullinan's recount of Mrs. Jordan's deadly fall were severely questioned. Dr. Wood claimed that falls from standing height with impact to the face or chin may result in fractures of cervical vertebrae, but most of which are survived. She claimed that only a few acute deaths may occur in individuals with important medical morbidities. Some injuries may result in immediate unconsciousness, but ongoing pulse and breathing. Dr. Wood argues that her experience with fatal falls downstairs consists of more than 25 cases, therefore doubting the cause of Mrs. Jordan's death. As well, the police traced phone records for Cullinan and Miss Jordan's texts and conversations, finding incriminating material that suggested that Cullinan was often both violent and tempered in their relationship. "Don't keep hurting me, please. I'll call the cops," and other evidence of the like revealed the nature of their complicated relationship. The defense argued that Dr. Wood's position was too speculative, but the Crown concluded otherwise. Through Dr. Wood's qualifications and experience, her opinions being far from speculative, the police investigation and ultimately Mr. Cullinan's confession to burning his partner's body enabled his sentence to life imprisonment under a second-degree murder or manslaughter. Analysis. This case was both obscure and tragic. Not only did it deal with murder and cruelty, but also with domestic violence. This case revealed a situation in the household that no one from the outside could imagine, and it ended with the life of yet another woman. Coming from a country like Spain, where women and girls are constantly attacked and murdered by their sentimental partners, I think the R.V. Cullen decision sets a precedent for the cases to come, but also rightly addresses this type of violence in crime. Although there was no clear or direct evidence that Cullen had murdered Miss Jordan, the court decided to make certain assumptions and decisions and ultimately condemned such actions, regardless of the level of evidence. That is that Cullen was rightly punished for his cruelty by quite a coherent decision. Therefore, I personally agree with the decision made by the Supreme Court of Nova Scotia, since I think there was enough evidence to conclude that Cullen was using violence upon his partner until it became a tragedy, and I fully support life imprisonment sentences for murders. I think it is both reasonable and humane to consider the cruelty of Mr. Cullen, as he burned the body to eliminate proof of murder and confessed, partly, to this incident only a couple of months ago, when Miss Rita Jordan had lost her life almost 3 years ago. Survey question. Regarding Dr. Wood's examination of Miss Jordan's death, do you agree with the court in admitting certain assumptions about the nature of a fall, in this case, to determine the authority of the crime?